Hello, my name is Naomi Wilson and I provide legal advice to landlords and tenants here at Assell Paterson. Today we're going to discuss some of the common misconceptions that landlord clients have about whether or not their tenants have a right to stay in the property at the end of a commercial business lease. The Landlord and Tenant Act 1954 protects all commercial business tenants so that at the end of their lease term, they have a statutory right to require their landlord to grant them a new lease in similar terms to the existing lease. You would need to discuss the issue with your tenant before the lease is signed and make sure they understand that they're going to contract out of those security of tenure provisions afforded by the 1954 Landlord and Tenant Act. They will need to sign a declaration which confirms that before they completed their lease with you as the landlord, they were served a notice explaining to them that they were going to have to contract out of their security of tenure provisions, and they would then sign a declaration to confirm that they had been served with the notice and they understand that at the end of their lease term they won't have any protection and they will have to vacate. If they don't contract out of the 1954 Act, then they are protected at law, and at the end of the lease term they will have a right to require you to grant them a new lease. If you haven't contracted out of the 1954 Act, there are some grounds for possession, but they are very specific. You would have to prove to a tenant or a court, if necessary, that you wanted the property back to occupy yourself, or you had plans to develop the property, or the tenant had a long history of failing to pay rent or breaching material covenants in the lease, or because you only rent out part of your property to this tenant, you would have a better chance at a better rent if you were able to bring this lease to an end and then rent out the entire property to a tenant. They have to sign the declaration to say they've been served with the notice and they understand what they're doing before the lease completes. So once the form of lease is agreed between the landlord and the tenant solicitor, the tenant will sign the declaration. If it's fewer than 14 days before the date that they complete their lease and take up occupation, they have to swear a statutory declaration in front of an independent solicitor. If it's more than 14 days before, then they just sign a simple declaration that doesn't need to be witnessed by another solicitor. Ordinarily, a copy of the notice that was served on the tenant and the declaration that they signed will be attached to the back of the lease, so everybody knows at the end of the term what was agreed and whether or not the tenant has to vacate. If you're a landlord with an agent and the agent finds your tenant and agrees the heads of terms, the agent will raise the issue with you and the tenant before your solicitor is instructed. But if you found the tenant yourself without the help of an agent, you'll need your solicitor to raise it with the tenant or the tenant's solicitor before the lease is agreed. If you have any questions about a lease that you have or a lease that you are potentially going to grant to a tenant concerning the 1954 Act, or any other queries about a lease, please feel free to get in touch with us here at Assell Paterson. You can phone, contact us on the website or send us an email. Thank you.